The following program is a production of Stetson University College of Law.
Welcome. I'm Professor Charlie Rose, and this is Practice Ready Evidence. Good day. Wherever you are, I greet you digitally. If you're watching this, you're watching one of a series of evidence lectures, sort of mini pieces of digestible, practical evidentiary law that are produced here at Stetson University College of Law and provided to you to help you understand how the federal rules of evidence work. Think of them as an overview of the specifics of the rules, a black letter presentation designed to get you thinking practically about how I might use evidentiary law. Why don't we go ahead and get started? We're going to work ourselves today. We're concerned with Article 1, the first article that sort of lays the groundwork for the federal rules of evidence. Now, Article 1 are generally referred to as the general provisions of the evidentiary rules, and they're designed to help us understand the scope, the structure, the way in which the rules are supposed to work. If we take a look at our slide here, when we're talking about the Article 1 general provisions, we begin with the idea that the federal rules of evidence are a codified development that grew out of the fundamental common law underpinnings that exist within the United States. It was an attempt to take the common law and to condense it down to its core concepts and aspects, and then to apply it evenly over the entire United States. And there was a very interesting thing that happened as we begin with this scope of the federal rules of evidence. The historical common law approached evidence from a very interesting perspective, which was basically nothing is admissible unless we have a specific rule that allows for its admissibility. So when I think of the common law of evidence, it was law that was built around the concept of exclusion. Most things are out and only a very few identified things are in. And that fundamental approach was turned on its head when we developed the federal rules of evidence, because they were designed to specifically ensure that all evidence that is relevant is admissible unless it is specifically excluded. That takes the concept of evidentiary law and turns it on its head, pushing towards more information to the jury, more information to the finder of fact, and more possibilities, quite frankly, from both an advocacy and a substantive law perspective. And it's a key concept that we need to keep in our minds as we're thinking about evidentiary law going forward. And we see that in the designation of the scope of the rule under Federal Rule of Evidence 101, and the discussion and the commentary and the comments about how federal evidentiary law developed. Now, if I go and look at Federal Rule of Evidence 102, it talks about the purpose, the construction of the rule, the move to codification, and the way in which the rules are set up. For our purposes, you and I, as practicing attorneys who are interested in the way in which these rules impact the application of the law to facts at trial, Federal Rule of Evidence 101 and Federal Rule of Evidence 102 are designed primarily to sort of lay the groundwork for why the rules are the way they are. But they're not something that we turn to each and every day in our decisions about how we're going to present evidence at trial, what our rights and responsibilities are, and what the rights and responsibilities might be of other parties. That changes when I begin to look at Federal Rule of Evidence 103. 103 is the first rule that actually begins to talk to me substantively as an attorney about what I can or cannot do. It establishes some rights and responsibilities of counsel, and it gives us some ideas about preserving the record and ensuring waiver at trial. Now, what I want to do for you is to pull up a copy of the rule from an electronic book that I have available, and we're going to look at this book, and then we're going to go through the language of some of the rules. Now, this is Federal Rule of Evidence 101. And it gives the scope and the definition of the rules. We've talked about that already. We're not too terribly concerned with it today. But I really want to look at Federal Rule of Evidence 103, which talks about preserving a claim of error. Parties have the ability to claim error when the judge makes a mistake on admitting or excluding evidence. And 103 goes through the process of how that's supposed to work. And in a nutshell, it's like this. If the error is so egregious that anybody should have seen it and should have done something about it at the trial level and all the parties didn't do so, that's going to potentially be an issue on appeal. But if it's not that outside the boundaries of the law, and believe you me, from a practical perspective, that almost never happens. There's a duty on the part of the attorney who has been harmed, whose case has been harmed by the ruling of the judge, to properly make the record. To make the record so that the appellate court can consider in an appropriate fashion whether or not the judge made a mistake. So, that means when I object as a lawyer at trial, or when I raise a motion in limine to exclude evidence, if the judge rules against me, I need to preserve that issue for the record. So with an objection, it's relatively easy. If I stand up and say, "Objection, Your Honor," well, that's a general objection. It hasn't oriented the judge or the appellate court to the specific issue that I see. If I stand up on the other hand and say, "Objection, hearsay, may I be heard," what I've done is told the judge that I think this is an issue of hearsay, that a statement that's not admissible under the rules is going to be admitted, and I want an opportunity to make argument. By saying objection hearsay, I'm also informing the appellate court of what I think the issue might be. And it's my duty as the counsel to make that objection under 103. I have that responsibility. If I don't make an objection to evidence that might have otherwise been admissible, I run the potential of having waived that objection at the appellate level. Now, there used to be an issue in the federal system as to what happened when I raise an objection in a motion. I do a motion in limine trying to exclude evidence, I lose that motion, and the judge rules dispositively. And we used to not know, there used to be a split in the circuits as to whether or not that objection was then preserved for appeal, or did I have to make the objection again during the actual trial. Now, if you'll think about it for a moment, if I'm objecting to the admissibility of a piece of evidence, it's because it hurts my case. If I lose a motion in limine that I've made about that piece of evidence, I know the judge is going to let it in at trial. He's going to let the other side lay the foundation and admit that evidence. If I object again at trial, I'm underlining the impact that this evidence has on my case, and I'm unnecessarily highlighting it so that the jury is going to pay attention to it. And if the judge has already ruled on my objection through a motions practice session, why should I be required under the rule to make that objection again to preserve the issue for appeal? There was a split in the circuits. Some circuits thought you had to make the objection again to preserve the issues. Others did not. Well, the rule was changed to make it clear. Once the judge has ruled dispositively on a motion to exclude or include evidence, if I'm the losing party, once the judge has ruled on it, I have preserved that issue for appeal, and I don't have to object again at trial. Now, I have the ability to, and I may want to, if I think the judge might change her mind because of something that happened from a foundational perspective or other evidence that was admitted at trial, or perhaps I want to make the objection to highlight some issue about the evidence that I intend to bring up during my case in chief. In either one of those sets of circumstances, though, that's my choice. The rule does not require me to do it. It's important as counsel that we understand our responsibilities when it comes to objecting to the admissibility of evidence. If we're not doing this the right way, we run the risk of allowing opposing counsel to properly set the battlefield from an evidentiary perspective, win at trial, and then we're denied the potential for relief at the appellate level. And that's not the way you want to do it. It's important to get this right. The last thing that I'll give you as a tip under Rule 103 is that you really need to watch and see whether or not the judge is truly ruling on your issues. If the judge says something like, well, counsel, I'm going to take this under advisement. I'm going to reserve ruling until I've heard the witnesses testify. and she says that during the motions hearing, guess what she's just done? She's kicked the can down the road. And now it remains under 103 your responsibility to raise that objection again when it arises at trial. And if you don't, you've just waived it. Even though you may have felt like you won the argument during the motion, the judge does not rule, you've lost the battle when it actually comes to trial. This is something you need to remember. It's something you as counsel have to take responsibility for. The judge is concerned with not being overruled on appeal. You should be concerned with making certain that your client's rights are respected and protected throughout the process. And that includes, at a very fundamental level, motions to suppress, motions to include, and objections on the record as to the admissibility of evidence. 103 is the rule that controls the process for that happening. Let's take a look at Federal Rule of Evidence 104. 104 is different in that 104 is now looking at the responsibilities of the judge, what the judge is required to do. And what 104 tells us is that it's the judge's responsibility to make decisions regarding the admissibility of evidence. From a Federal Rules of Evidence perspective, the judge is in a very real sense the gatekeeper to admissibility. The judge decides what the jury will or will not hear based upon their power under Federal Rule of Evidence 104. Now, the judge does not decide the weight that the jury should give to the evidence. That's the jury's responsibility. The jury weighs the credibility of the evidence once it makes it through the gate of the judge. But the judge has this gatekeeping authority, and 104 sets the parameters for that gatekeeping authority. And it's interesting in a couple of different ways. First of all, the judge is not bound by admissible evidence in the federal system when making determinations of admissibility. Let me say that again. The judge can consider evidence that is otherwise inadmissible when determining whether or not another piece of evidence might be admissible. That is a unique component of the Federal Rules of Evidence, and many state codes, to include, for example, the state of Florida, do not allow a judge to consider impermissible evidence when ruling on the admissibility of other evidence. But the federal judges are allowed to do so under the Federal Rules of Evidence. There's one caveat there. They cannot consider privileged information when making that determination. Now, when we think about this balancing test that a judge engages in under Federal Rule of Evidence 104 to determine the admissibility of a piece of evidence, we've already established that they don't have to consider admissible evidence. It's any evidence that might tend to prove or disprove. And the standard is, would a jury potentially consider that fact as having been proven or having been shown? So it's not a beyond a reasonable doubt standard. It's not a clear and convincing standard on the part of the judge. It's not even a preponderance of evidence standard on the part of the judge. The standard is, would a jury, looking at this information, potentially decide that the evidence is admissible? If I can get to that point, then I can argue that the judge should allow this evidence into trial. It's very often either a question of foundation, when it's an exhibit or a piece of evidence, or a question of hearsay, a question of character, sometimes a question of privilege. The judge has that authority under the federal rules to determine admissibility, which means questions of admissibility are directed to the judge and not to the jury. Questions of weight and credibility are arguments that we make to the fact finder and not the judicial arbiter. So when I'm talking to the judge, I'm talking about legal standards. When I'm talking to the jury, I'm talking about factual standards. And I have to keep those two straight in my mind. Now, because the judge has the ability to admit evidence for one purpose and not for another purpose, and because evidence might be relevant in one way but not allowed under the rules in another way, we have this concept in the Federal Rules of Evidence that is called limited admissibility. Limited admissibility works like this. If it's in for one reason but not for another, at the request of counsel, the judge can give a limiting instruction to the jury concerning that piece of evidence, specifically telling the jury that they may use this evidence in one way in their deliberations, but are not allowed to use the evidence in another way for their deliberations. Let's say I've got a prior inconsistent statement by a witness that is not consistent with what they've said under oath, subject to cross-examination at trial. That prior inconsistent statement, though, is not in and of itself admissible under the hearsay doctrine. Let's say it's a handwritten statement that was given to the cops at the time an accident scene was, the time an accident occurred. I can offer that handwritten statement to impeach the witness, to show that they've changed their story, to attack their credibility, but I can't offer it substantively to prove what's contained within the document because it doesn't have a hearsay exception. So an appropriate limiting instruction from the court might be, members of the jury, you've heard testimony concerning a prior statement made by the witness about what was observed at the time of the accident. I am instructing you that you are allowed to consider that prior statement for its effect on your weight as to the credibility, the truthfulness of that particular witness when they testified under oath. It is not, however, substantive evidence to prove the contents of that earlier statement. You should follow my instructions. That's a classic example of a limiting instruction from the judge. Limiting instructions can be different depending upon the jurisdiction. In the federal system, the judge can instruct on the limiting instruction when the evidence is heard by the court, or at the close of trial, when the judge gives all the instructions to the jury, and sometimes they can even do it in both instances. As the attorney, you have to make a decision about whether or not you want to ask for that limiting instruction, and if you do, when you want to ask for the limiting instruction. Limiting instructions do a good job of defining the legal issue so that if opposing counsel improperly argues evidence that's been limited in another fashion, it's not going to be admissible, and I've got an appellate issue because of improper argument. It's another question, however, as to whether or not a limiting instruction truly unrings the bell in the mind of the jury. Can the jury hear something and then be told not to pay attention to it for one reason, but to pay attention to it from another reason? Well, cognitively, we think that we can instruct people to do that, although a review of the literature in psychology would seem to indicate that, as a matter of fact, limiting instructions could fairly be called a legal fiction, in that they create this inference, but they don't really accomplish that objective. If that's true, I may, as a lawyer, choose not to ask for the limiting instruction because I don't want the judge to highlight and underline for the jury this evidence that they've already heard that I feel hurt my case, because I'm concerned that they may use it in a way that the law doesn't allow. And if the case has gone the right way, I've already made the record by having objected to the evidence and gotten it limited to a certain degree. It's something that we have to think about when we're dealing with limiting instructions under 104. So 104 and limiting instructions under 105. So 104 and 105 sort of outline the powers of the judge and the way in which the court determines the admissibility of evidence and how the judge can limit the use of evidence for one purpose and deny its use for another purpose. There are important rules, 103, 104, and 105, for us as we begin to understand the way evidence works at trial, because they outline the responsibilities of the parties, and it's something to keep in mind. The last federal rule of evidence under the 100 series, the general article that I need to talk to you about, is what's usually referred to as the rule of completeness. Now here the rule says remainder of or related writings or recorded statements. What we're really talking about here is when one side admits a piece of a prior statement, the other side ought to, in all fairness, be allowed to admit the rest of the statement, even if they did not otherwise have a potential hearsay argument for its admissibility. The classic example is where the state in a criminal case admits a portion of the oral statement made by the accused to a cop, and they do it through the testimony of the cop on the stand. But they don't admit other pieces of what the defendant told the cop during that interview because they're exculpatory as opposed to inculpatory. Now, as the defense attorney, normally I could never introduce what my client said to a cop because I don't have a hearsay exception for that unless I put my client on and have the client testify. But if the state puts the cop on the witness stand, the cop testifies about a portion of what my client says. In order to put that portion that he testified about in context so the jury can fairly understand it, I would be allowed as the defense attorney to admit the rest of what my client said through the cross-examination of the police officer. If it was a written statement, I'd be allowed to put in the rest of what was said under the written statement. The rule talks about writings, but the common law that has applied Federal Rule of Evidence 106 also allows us to apply it and consider it as it relates to oral statements. So it's really any statement, not just a written statement. And it's an important rule to understand, particularly if you're a criminal defense lawyer or if you're representing a defendant against a plaintiff in a civil action and they want to admit portions of what your client has said to make it look like you're liable, but are excluding other portions that may explain why your client is not in fact liable. It could be a very helpful rule, and practically speaking is one that gets applied quite a bit in litigation, particularly litigation involving documents that are statements by the parties. So that kind of concludes our coverage of Federal Rule of Evidence 106. In other sections of practice-ready evidence, we're going to look at other general articles, and we're going to talk about how they relate to the specifics of practicing evidentiary law to the benefit of the client. Till next time, I'm Charlie Rose. We'll catch you down the road.